What's your business in the VIP lounge? People like you can't afford it.
Why are you touching me like that?
Keep your voice down. Give me the ID or you're not getting past this checkpoint. You make one wrong move, I'll have you detained.
You just harassed a federal lawyer. Think about that before you take another step.
The security camera footage would later show exactly what happened that August 19, 2024. Officer Daniel Mercer had only 7 months on the job when he destroyed his entire future inside Miami International Airport for absolutely nothing. He saw a black woman in an executive dark blue suit entering the VIP priority boarding queue. No crime, no alert, no threat. But in Mercer's mind, that was enough. Emotion replaced training. Bias replaced procedure. Suspicion replaced law. That black woman was attorney Breanna Lewis, a respected federal DOJ lawyer who spent nearly 2 decades holding police departments accountable in federal courtrooms. What happened next would detonate national outrage, force congressional commentary, and ultimately cost this rookie cop $30 million. Before we continue, where are you watching from? If this is your first time here, please hit that subscribe button. Stories like these need to be shared, and your support helps us bring more truth to light. Miami International Airport processes over 45 million passengers annually. It's a sprawling complex of terminals, gates, security checkpoints, and retail spaces that operate with mechanical efficiency. On any given day, thousands of travelers move through its corridors, business executives, tourists, families, students, all flowing through the standardized rituals of modern air travel. August 19, 2024 was unremarkable by airport standards. The morning shift was routine. Flights departed on schedule. Security lines moved steadily. The air conditioning fought against the Miami heat that pressed against the terminal windows. Officer Daniel Mercer was assigned to Terminal D that morning. He wore the uniform of the Miami-Dade Police Department's Airport Division. 7 months into the job, still in his probationary period, still learning the rhythms of airport security, the jurisdictional boundaries between local police and federal TSA, the protocols for responding to actual threats versus perceived irregularities. Mercer was 25 years old. His academy performance had been adequate but unremarkable. His field training reports noted a tendency toward overconfidence that didn't match his limited experience. His supervisors had flagged concerns about his judgment in ambiguous situations, a preference for action over assessment, intervention over observation. But none of that had prevented him from receiving a badge, a weapon, an assignment to one of the busiest airports in the United States. Mercer stood near the VIP priority boarding queue for Gate D12. The queue served first-class passengers and airline loyalty program elite members. It was shorter than the main boarding line, moving faster, occupied by travelers who carried themselves with the assured posture of people accustomed to preferential treatment. Attorney Breanna Lewis approached the VIP queue at approximately 9:47 a.m. She wore a tailored dark blue suit. Executive cut. Professional. Her carry-on bag was leather, wheeled efficiently behind her. Her boarding pass was already pulled up on her phone. Everything about her presentation communicated competence, purpose, and belonging. Lewis was 43 years old. She had spent 17 years with the Department of Justice's Civil Rights Division. Her specialty was police misconduct litigation. She had prosecuted cases under 18 U.S.C. Section 242, criminal civil rights violations committed by law enforcement officers. She had secured convictions against officers who had used excessive force, conducted unlawful searches, and violated citizens' constitutional rights under color of law. She knew the law. She knew police procedures. And she knew exactly what lawful authority looked like and what it didn't. Lewis was returning to Washington, D.C. from a 3-day conference in Miami, focused on prosecutorial strategies for addressing systemic police violence. She was tired. The conference had been intense. Panel discussions, case reviews, strategy sessions that stretched late into the evening. She just wanted to board her flight, settle into her seat, and decompress during the 2-hour journey home. She stepped into the VIP queue behind 2 other passengers. She glanced at her phone, checking the time. Boarding would begin in 15 minutes. Officer Mercer watched her join the line. Something shifted in his posture. His head tilted slightly. His eyes tracked her movement with focused attention. The security camera footage from the terminal would later capture this moment, the exact second when Mercer decided that Lewis required investigation. She hadn't run, hadn't looked around nervously, hadn't exhibited any behavior that would constitute reasonable suspicion under Fourth Amendment standards. She was simply standing in a queue designated for first-class passengers and airline elite members. But in Mercer's assessment, that required explanation. The internal justification loop that occurs in these moments is rapid and largely unconscious. The officer sees something that doesn't match their expectations. Their brain searches for explanations. Bias provides the easiest narrative. This person doesn't belong here, which means they're probably doing something wrong, which means intervention is justified. It's circular reasoning, but it feels like logic to the person experiencing it. Mercer left his position and walked toward the VIP queue. His stride was deliberate, purposeful, the body language of someone who has decided that action is required. Lewis noticed him approaching. She looked up from her phone with the neutral expression of someone accustomed to navigating public spaces. Not concerned, not alarmed, just aware that a police officer was walking in her direction. Mercer stopped directly in front of her, blocking her position in the queue. "Excuse me, ma'am," he said, his tone carrying that particular blend of false courtesy and implicit challenge that officers use when they want compliance without having to explicitly demand it. Lewis met his eyes. "Yes, officer. Can I see your boarding pass and identification?" It was phrased as a question, but the expectation of compliance was absolute. Lewis' expression shifted slightly, not to anger, not to fear, but to recognition. She had prosecuted cases that began exactly like this. She knew the pattern. "Is there a problem?" she asked, her voice professionally neutral. "I'm conducting a security check," Mercer replied. "A security check of what?" "I'm standing in a designated boarding queue for first-class passengers. I haven't violated any airport policy or security protocol." Mercer's jaw tightened fractionally. He wasn't accustomed to having his authority questioned, especially not by civilians, especially not in the first 15 seconds of an encounter. "Ma'am, I need to see your boarding pass and ID. Now." The now was the tell. The moment where request became command, where the pretense of voluntary cooperation dissolved into demand. Lewis calculated her options. She could comply, hand over her identification, let this officer run his checks, endure the humiliation of being singled out in front of other passengers, accept the violation and move on with her day. Or she could assert her rights, require this officer to articulate legal justification, force him to operate within constitutional bounds. She had spent 17 years at the DOJ teaching officers that citizens have rights, that authority requires justification, that the badge doesn't grant unlimited power. And she refused to surrender those principles just because she was the one being targeted. Is this where bias becomes a pretext to manufacture suspicion? "Officer, on what legal basis are you requesting my identification?" Brianna Lewis asked, her voice steady and clear. Daniel Mercer took a small step closer, narrowing the physical space between them. It was a dominance technique. Subtle but deliberate. Use proximity to create pressure. Make the target feel uncomfortable. Increase the likelihood of compliance. "I don't need to explain myself to you," Mercer said. "Airport security. That's my basis. Airport security handled by TSA is located at the security checkpoints," Lewis replied calmly. "I've already passed through federal screening. I'm now in a secure area of the terminal, standing in a designated boarding queue. You're local law enforcement, not TSA. So I'm asking again, what specific security concern justifies this stop?" Other passengers in the VIP queue were watching now. The interaction had captured attention. Phones were being pulled from pockets. The moment was being documented. Mercer's face flushed slightly. He was being corrected, publicly, by someone who clearly understood jurisdictional boundaries better than he did. "Ma'am, if you don't cooperate, you're not getting on that plane," he said, his voice harder now. "Cooperate with what? You haven't articulated any lawful basis for this encounter." Mercer reached out and grabbed Lewis' arm just above the elbow. Not violently, but firmly. A physical assertion of control. Lewis pulled her arm back immediately. "Do not touch me. I'm conducting a security search," Mercer said, reaching for her again. "You have no authority to conduct a search. I haven't consented. You haven't articulated reasonable suspicion. And you certainly don't have probable cause." But Mercer wasn't listening anymore. He had committed to the encounter, had asserted his authority, and now he needed to follow through or risk looking weak in front of witnesses. He grabbed Lewis' arm again, this time with both hands, and began patting the sides of her suit jacket. His hands moved across her shoulders, down her arms, along the sides of her torso. It was invasive, humiliating, and completely unlawful. Lewis stood rigid, her arms slightly away from her body, not resisting physically but clearly not consenting. Her face showed shock mixed with outrage. Her voice, when she spoke, was controlled but sharp. "You are conducting an unlawful search. I am a federal attorney. I am explicitly telling you that you do not have my consent. You are violating my Fourth Amendment rights. And you are doing it in front of witnesses." Mercer's hands moved to the pockets of her jacket, patting them, checking for what? He hadn't articulated what he was searching for. Weapons? Contraband? Evidence of a crime that didn't exist? The search had no objective. It was pure performance. An assertion that he could touch this woman's body because he wore a badge and she had questioned his authority. "Why are you touching me?" Lewis asked, her voice rising slightly now, emotion breaking through the professional composure. "What crime do you think I've committed? What are you looking for?" Mercer didn't answer. He stepped back, having completed his invasive pat-down, and looked at her with an expression that suggested he had been perfectly reasonable and she was the one making this difficult. "Your boarding pass and ID," he repeated. The passengers in the VIP queue were openly recording now. Multiple phones, multiple angles. The gate agent at the desk was on her communication device, likely calling a supervisor. The encounter had escalated beyond what anyone had expected. Lewis' hands were shaking slightly, not from fear, from fury, from the violation of having her body touched without consent by someone who believed a badge granted him that right. She had prosecuted officers for this exact conduct, had argued in federal court that unlawful searches violate fundamental dignity, had secured convictions and settlements for victims who had experienced what she was experiencing right now. But intellectual understanding and personal experience are not the same thing. The violation felt different when it was happening to her. Should a citizen ever have to explain basic bodily autonomy to a trained officer, to understand why Officer Mercer's conduct was unlawful from the moment he touched Brianna Lewis? You need to understand the jurisdictional boundaries that govern airport law enforcement. Transportation Security Administration officers, TSA agents, operate under federal authority. They conduct security screening at designated checkpoints. Their authority is limited but specific. They can search passengers and their belongings as a condition of entering the secure area of the airport. This is considered an administrative search, and by presenting yourself for boarding, you consent to it. But once you pass through TSA screening and enter the secure area of the terminal, that authority ends. You've been cleared. You're in a controlled space where everyone has already been screened. Local law enforcement officers assigned to airports, like Officer Mercer, operate under different rules. They're governed by the same constitutional standards as any other police officer. They need reasonable, articulable suspicion to conduct an investigatory stop. They need probable cause to make an arrest. And they need either consent, a warrant, or an exception to the warrant requirement to conduct a search. Officer Mercer had none of these things. He approached Lewis without reasonable suspicion. She hadn't committed any crime. She hadn't exhibited any suspicious behavior. She was standing in a designated queue for first-class passengers, which she had every right to do. He demanded identification without legal justification. Simply being in an airport doesn't eliminate your Fourth Amendment rights. Officers can't demand ID from passengers who have already cleared security and are waiting to board unless they have specific, articulable facts suggesting criminal activity. And he conducted a physical search without consent, without a warrant, and without any legal exception that would justify touching her body. This wasn't a Terry frisk for weapons. Mercer didn't articulate any belief that Lewis was armed and dangerous. He didn't claim to fear for his safety. He simply decided that her refusal to immediately comply with his demands justified putting his hands on her. Under Fourth Amendment case law, this is unequivocally unlawful. The Supreme Court has held repeatedly that the government cannot conduct searches without individualized suspicion. That bodily searches are among the most intrusive forms of government action. That consent must be voluntary, not coerced through the implicit threat of force. Mercer violated every one of these principles. But here's what makes this case particularly significant from a legal perspective. Unlawful searches often multiply liability risk faster than even violent force cases. When an officer uses excessive physical force, The legal analysis focuses on whether the force was objectively reasonable given the circumstances. Courts give officers some leeway in rapidly evolving situations where split-second decisions are required. But unlawful searches don't happen in split seconds. They're deliberate, calculated. The officer has time to think, to assess, to consider whether their actions are legally justified. Mercer had time. Lewis explicitly told him he was violating her rights. She stated clearly that she did not consent. She identified herself as a federal attorney. And he proceeded anyway. That's not a split-second error in judgment. That's willful violation of clearly established constitutional rights. And willful violations destroy qualified immunity defenses. They open officers to personal liability. They expose departments to massive settlements. They create the kind of legal exposure that makes city attorneys panic. The legal framework governing Mercer's conduct was well established. Terry v. Ohio defined investigatory stops. Florida v. Royer clarified that airport encounters require the same constitutional protections as any other police interaction. Brenlin v. California confirmed that passengers have standing to challenge unlawful seizures. Every one of these cases was decided decades before Mercer put on a uniform. The law was clear. The training should have been clear. The constitutional boundaries were not ambiguous. Mercer chose to ignore them, and that choice would cost him everything. If police don't know where their authority stops, how can the public ever feel safe? Breanna Lewis stood in the VIP boarding queue with her arms at her sides, breathing carefully, forcing her professional training to override the anger and humiliation coursing through her. Officer Daniel Mercer was still standing in front of her, blocking her path, waiting for compliance that he believed was inevitable. Other passengers watched in uncomfortable silence. The gate agent was off to the side, speaking rapidly into her communication device. Security cameras captured everything from multiple angles. Lewis made a decision. She reached into her suit jacket pocket slowly, making sure her movements were visible and deliberate. She pulled out a black leather credential case and held it at chest height where Mercer and the surrounding cameras could see it clearly. She opened the case. Inside was her Department of Justice identification card bearing the seal of the United States government. Next to it was her federal prosecutor badge. Below that was her federal bar credential authorizing her to practice in federal courts nationwide. She held the case steady, her hand no longer shaking, her voice absolutely level when she spoke. My name is Attorney Breanna Lewis. I am a federal prosecutor with the Department of Justice's Civil Rights Division. I have spent 17 years investigating and prosecuting law enforcement officers for civil rights violations. I specialize in cases involving unlawful searches, excessive force, and misconduct committed under color of law. She paused, letting the words settle. You approached me without reasonable suspicion. You demanded identification without legal justification. You conducted a physical search of my body without my consent, without a warrant, and without any legal exception that would authorize such contact. You violated my Fourth Amendment rights. You did it deliberately after I explicitly informed you of the constitutional violations you were committing, and you did it in front of multiple witnesses while being recorded from several angles. Mercer's face had gone pale. His mouth opened slightly, but no words came out. His hands dropped to his sides. The aggressive posture collapsed into something closer to shock. The gate agent had stopped talking into her device and was staring at the scene unfolding. A passenger near the front of the queue whispered, "Oh my God." Another voice from farther back, "He just searched a DOJ lawyer?" Lewis closed her credential case, but didn't put it away. She held Mercer's gaze with the steady intensity of someone who had cross-examined hostile witnesses in federal court and wouldn't be intimidated by a rookie cop's authority fantasy. I will be filing a formal complaint with the Department of Justice's Office of Professional Responsibility, Lewis continued, her voice carrying through the gate area. I will be filing a complaint with the Miami-Dade Police Department's Internal Affairs Division. I will be filing a civil rights lawsuit under 42 U.S.C. Section 1983 for violations of my constitutional rights. And I will personally ensure that every frame of video from this encounter is reviewed by federal prosecutors who will determine whether your conduct rises to the level of criminal civil rights violations under 18 U.S.C. Section 242. Mercer took a step backward. His hand moved to his radio, but he seemed uncertain what to do with it. Call for backup? Report the encounter? Admit what he had just done? An airport supervisor was approaching now, alerted by the gate agent's call. A middle-aged man in a white shirt with supervisor insignia, walking quickly but not running, trying to assess the situation before arriving. Lewis turned slightly to address the supervisor as he approached. "I'm Attorney Brianna Lewis with the Department of Justice. This officer just conducted an unlawful stop and search. I need his name, badge number, and body camera footage preserved immediately." The supervisor looked from Lewis to Mercer, processing what he had just walked into. His expression suggested he understood immediately that this was not a situation that could be smoothed over with apologies and de-escalation. "Ma'am, I'm Supervisor Chun. I apologize for any confusion. Let me—" "There's no confusion," Lewis interrupted, her voice still controlled but carrying an edge now. "Officer Mercer approached me without cause, demanded identification without legal justification, and physically searched my body without consent after I explicitly informed him he was violating my constitutional rights. This isn't confusion. This is misconduct, and it will be documented, investigated, and prosecuted as such." Supervisor Chun turned to Mercer. "Is your body camera active?" Mercer nodded weakly. "Good. Don't turn it off. Return to the security office immediately and wait there. Don't speak to anyone about this incident except internal affairs investigators. Do you understand?" Mercer nodded again and walked away, his stride no longer confident, his shoulders hunched, the visible posture of someone who had just realized they destroyed their career. Lewis watched him go. She was still holding her credential case. Her hands had stopped shaking, but the adrenaline was still there, keeping her alert, focused, professional. The supervisor turned back to her. "Ma'am, I sincerely apologize for what just occurred. I want to assure you that this will be investigated thoroughly and—" "Save the institutional response for the formal investigation," Lewis said, cutting him off. "Right now I need you to preserve all video footage from terminal cameras, gate cameras, and Officer Mercer's body camera. I need his full name and badge number. And I need confirmation that he's being removed from active duty pending investigation." Chun nodded, pulling out his phone to make calls. The machinery of institutional response was activating, but Lewis knew from experience that without external pressure, investigations often died quietly in administrative review. This one wouldn't, because she had the expertise, the resources, and the determination to ensure accountability. The passengers in the VIP queue had been silent throughout the exchange. Now, slowly, boarding resumed. The gate agent called the first group. People moved toward the jet bridge. Lewis waited until her group was called. She boarded the aircraft, found her first-class seat, and sat down. She pulled out her phone and began documenting everything while the details were fresh: times, exact quotes, witnesses, the sequence of events. By the time the aircraft pushed back from the gate, she had already drafted the outline of her formal complaint. The flight to Washington would take 2 hours. By the time she landed, the first formal notifications would be sent, and Officer Daniel Mercer's 7-month law enforcement career would be effectively over. Why do some officers require humiliation before they recognize humanity? Officer Daniel Mercer sat in the airport security office, body camera still recording, waiting for internal affairs investigators who were already en route. His mind was racing through potential explanations, ways to frame the encounter that would make his actions seem reasonable, narratives that would transform what happened from misconduct into a judgment error, stories that would protect him from the consequences he could feel approaching like a storm. This is what happens in the moments after officers realize they've made a career-ending mistake. The instinct isn't accountability. It's self-preservation. The mind immediately begins constructing defenses, rewriting memory to align with justification rather than fact. Mercer wanted to believe he had acted on legitimate security concerns, that Lewis had been evasive or suspicious in some way that justified his intervention, that her refusal to immediately comply had forced him to escalate. But the body camera footage would tell a different story. It would show him approaching a woman standing calmly in a boarding queue. It would capture his inability to articulate any specific suspicious behavior. It would record Lewis explicitly stating that he was violating her rights. And it would document him proceeding with a physical search anyway. There was no reframing that would make this look good. Supervisor Chin entered the security office with another senior airport official. Their expressions were grim. They had already reviewed the preliminary reports. They understood the severity of what had occurred. Officer Mercer, you're being placed on administrative leave effective immediately, Chen said. Internal Affairs has been notified. They'll be conducting a full investigation. You're required to surrender your duty weapon and badge. You will not discuss this incident with other officers or anyone outside of official interviews. Do you understand? Mercer nodded. His throat was tight. This was real. This was happening. I was just doing a security check, he said, the words sounding weak even to himself. She was acting suspicious. Don't, Chen interrupted sharply. Don't make statements that aren't documented. Wait for IA. Speak with your union representative. But do not try to construct a narrative right now that you think will help you. The cameras captured everything. That was the reality sinking in. The cameras captured everything. His approach. His demands. Lewis identifying herself as a federal attorney. The physical search. All of it documented from multiple angles with audio that would leave no ambiguity about what was said. Mercer handed over his badge and weapon. The physical relinquishment of the tools that had defined his identity for 7 months. Without them, he was just a 25-year-old with no clear career path and a misconduct investigation that would follow him forever. He left the security office and drove home in a daze. By the time he arrived, the story was already breaking on social media. Passengers who had recorded the encounter were posting videos. Legal commentators were analyzing the footage. Civil rights organizations were issuing statements. The video showed everything. Mercer approaching Lewis without cause. Her calm responses. His escalation. The unlawful search. And then the moment she revealed her DOJ credentials and his body language collapsed. The comments were brutal. Thousands of people weighing in, most expressing outrage, some defending Mercer as a young officer who made a mistake, but the overwhelming sentiment was condemnation. By evening, national news outlets had picked up the story. Rookie cop searches DOJ civil rights prosecutor was the headline across multiple platforms. The irony was too perfect to ignore. An officer who specialized in prosecuting police misconduct being subjected to the exact behavior she had spent her career fighting. The Miami-Dade Police Department issued a statement. It was carefully worded, acknowledging that an incident had occurred, confirming that an investigation was underway, and emphasizing the department's commitment to constitutional policing. But statements don't undo video evidence. Attorney Breanna Lewis landed in Washington and immediately filed her formal complaint with the DOJ's Office of Professional Responsibility. The complaint was detailed, precise, and supported by video evidence. It wasn't a request for internal review. It was a demand for action. She also retained a private civil rights attorney to handle the federal lawsuit she would be filing against Mercer and the Miami-Dade Police Department. This wasn't about money for Lewis. She earned a federal salary. She didn't need a settlement. But she understood that without financial consequences, departments don't change. Trainers don't get replaced. Hiring standards don't get raised. Cultural problems don't get addressed. Institutional change requires institutional pain. And that pain typically comes in the form of massive settlements that force budget conversations that reach city councils and police commissioners. The internal affairs investigation proceeded rapidly. Mercer was interviewed. He had a union attorney present. The attorney tried to frame the encounter as a misunderstanding, a rookie error, an example of insufficient training rather than malicious intent. But intent doesn't matter in civil rights cases. The Supreme Court has held that officials can be liable for constitutional violations regardless of their subjective intent if they knew or should have known that their actions violated clearly established rights. Mercer should have known. Lewis had told him explicitly that he was violating her rights. She had cited the Fourth Amendment. She had refused consent, and he had proceeded anyway. That's not lack of training. That's deliberate violation. The investigation concluded within 3 weeks. The findings were unequivocal. Mercer had conducted an unlawful stop and search. He had violated department policy. He had committed constitutional violations. His actions warranted immediate termination. Mercer was fired. His law enforcement career ended before his 8th month on the job. And unlike officers who are quietly terminated and moved to other departments, Mercer's misconduct was now part of the viral public record. He would never work in law enforcement again. Do systems protect truth, or do systems protect each other? Attorney Breanna Lewis filed her federal civil rights lawsuit in the United States District Court for the Southern District of Florida. The complaint was filed under 42 U.S.C. Section 1983, the primary statute allowing individuals to sue state actors for constitutional violations. The defendants were Officer Daniel Mercer, individually, and the city of Miami-Dade County. The complaint alleged multiple violations. First, a Fourth Amendment claim for unlawful seizure and search. Lewis argued that Mercer had stopped her without reasonable suspicion and conducted a physical search without consent or legal justification. Second, a 14th Amendment claim for violation of equal protection. The complaint argued that Mercer had targeted Lewis based on her race, subjecting her to scrutiny and search that white passengers in the VIP queue did not face. Third, a claim of assault and battery under Florida state law. Mercer had touched her body without consent and without legal authority, which constitutes unlawful touching under civil law regardless of his status as a police officer. Fourth, a claim of intentional infliction of emotional distress. The complaint detailed the humiliation, violation, and trauma of being publicly searched by an officer who ignored her explicit assertions of rights and continued touching her body despite her protests. The complaint sought compensatory damages for the constitutional violations and emotional harm. It sought punitive damages to deter future misconduct. And it sought injunctive relief requiring the Miami-Dade Police Department to implement reforms in training, supervision, and accountability mechanisms. The city's initial response was predictable. They filed a motion to dismiss, arguing qualified immunity for Officer Mercer. The argument was that the law regarding searches in airport settings was not sufficiently clear for Mercer to know his conduct was unlawful. It was a standard defense. Qualified immunity has become a nearly insurmountable barrier in many civil rights cases, protecting officers even when they commit clear constitutional violations. But this case was different, because the victim wasn't a typical plaintiff. She was a federal prosecutor who specialized in qualified immunity litigation. Lewis' opposition brief was surgical. She cited decades of case law establishing that suspicionless stops and searches violate the Fourth Amendment. She quoted Terry v. Ohio, Florida v. Royer, and numerous circuit court opinions that had addressed airport searches. She demonstrated that the constitutional principles Mercer violated were clearly established long before he became an officer. She also pointed out that Mercer had been explicitly informed during the encounter that he was violating her rights. He had been given real-time notice that his conduct was unlawful, and he had proceeded anyway. That destroys qualified immunity. The defense exists to protect officers who make reasonable mistakes about unclear law. It doesn't protect officers who are told they're violating rights and continue anyway. The judge denied the motion to dismiss. The case would proceed to discovery. The Miami-Dade Police Department released the full body camera footage under court order. The video was 23 minutes long, capturing Mercer's approach, the entire encounter, and the aftermath when Supervisor Chen arrived. The footage went viral. Millions of views across multiple platforms. Legal analysts broke it down frame by frame on cable news. Civil rights organizations used it as a teaching tool in workshops on police accountability. The video was devastating to any defense Mercer might mount. It showed a calm, professionally dressed woman standing in a boarding queue being approached without cause. It captured her measured, articulate responses. It documented her explicit statements that Mercer was violating her rights. And it recorded the unlawful search of her body. There was no way to watch that footage and conclude that Mercer had acted reasonably. Discovery proceeded. Mercer was deposed. His testimony was halting and defensive. When asked why he approached Lewis, he struggled to articulate specific behavior that had raised his suspicion. He admitted she hadn't been running, hadn't been looking around nervously, hadn't been doing anything that would typically warrant police attention. She just seemed out of place, he finally said. Out of place how? Lewis' attorney asked. I don't know. Just out of place. In a VIP boarding queue? Yes. And what about her appearance made her seem out of place? Mercer hesitated. He understood where the question was leading. I can't really say. Was it her race, Officer Mercer? No. I don't know. Maybe subconsciously, but I wasn't thinking about race. The admission was damaging. Not because explicit bias would have been better, but because it revealed the truth about how racial profiling actually operates. Not through conscious hatred, but through subconscious assumptions about who belongs where.
Sir, step away from the car. Whose vehicle is this?
It's mine. I'm just trying to go home.
People like you don't usually drive something like this. Let me see some ID. I just wrapped up a long day at work. I'm not giving you my license. There's no reason to.
Refusing? That's obstruction. I could put you in cuffs right now.
What I'm gonna do is read this. That's my judicial ID. I'm gonna sit in.
Rookie Officer Dylan Mercer had only been active on the Philadelphia Police Department for 7 months when he made the single most expensive mistake of his entire career. It happened in a quiet residential parking lot just after 7:30 p.m. No calls, no emergency dispatch, no threat. He simply saw a black man walking to his car and decided he didn't belong driving a car that nice. The man was wearing a black hoodie, blue jeans, and sneakers. Nothing about the moment was chaotic. Nothing about it suggested crime. But Mercer walked up anyway and demanded ID. The man told him he was going home after a long night shift. He declined to provide identification because there was no legal cause. Officer Mercer escalated instantly, and it would take only seconds before Mercer realized the man he was threatening was a Superior Court judge of the state of Pennsylvania. Before we continue, where are you watching from? If this is your first time here, please hit that subscribe button. Stories like these need to be shared, and your support helps us bring more truth to light. Philadelphia. Early evening. March 12th. The parking lot outside the Parkside residential complex was quiet. Most residents had already returned from work. A few cars remained scattered across the asphalt. The sun was beginning to set, casting long shadows across the pavement. Officer Dylan Mercer was 23 years old and had been on the Philadelphia Police Department for 7 months. 7 months of wanting to prove he belonged. 7 months of trying to show he was more than just another rookie. 7 months of believing that assertiveness meant competence and that suspicion meant vigilance. His training officer had noted in early evaluations, Officer Mercer displays enthusiasm but struggles with threat assessment and de-escalation. Tends to interpret normal civilian behavior as potentially suspicious. Recommend additional field supervision. But Mercer had been cleared for solo patrol anyway. The department was understaffed. Training periods were shortened. Red flags were documented and ignored. In his first 7 months, Mercer had already generated 3 citizen complaints. All involved stops that were later deemed unjustified. All involved people of color. None had resulted in disciplinary action beyond verbal counseling. The pattern was forming, but no one was paying attention. That evening, Mercer was cruising through the Parkside neighborhood on routine patrol. No calls pending. No incidents to respond to. Just driving. Watching. Looking for something. At 7:34 p.m., he turned into the parking lot of a mid-rise residential building and immediately noticed a black man walking across the lot toward a parked vehicle. Late model Mercedes. Silver. Clean. Expensive. The man was dressed casually, black hoodie, blue jeans, sneakers. He moved at an unhurried pace, keys in hand, clearly heading to the car. To anyone else, it would have looked unremarkable. A resident heading to his car. Someone leaving for the day. Someone who belonged. But Dylan Mercer saw something different. He saw a black man in a hoodie approaching a luxury vehicle. And in Mercer's mind, shaped by bias he'd never examined and assumptions he'd never questioned, that combination didn't add up. People like that don't drive cars like this. He didn't think it consciously. He didn't articulate it to himself. But the thought was there, operating beneath the surface, guiding his actions. Mercer pulled his patrol car into the lot and stopped near the Mercedes. He stepped out and walked toward the man with purpose. Judge Donovan Price had been up for nearly 20 hours. At 44 years old, Price was a Superior Court judge for the Commonwealth of Pennsylvania. He'd been on the bench for 6 years, presiding over criminal cases, civil litigation, and appellate matters. Before that, he'd spent 12 years as a trial attorney, specializing in civil rights law. His colleagues respected him. His rulings were rarely overturned. His reputation was built on fairness, precision, and an unwavering commitment to constitutional principles. But that night, or more accurately, that evening, had been grueling. He'd been working late on a complex case opinion, reviewing precedents, drafting language, ensuring every legal argument was airtight. By the time he finished, it was past 7 p.m. He'd showered in his chambers, changed into casual clothes, and headed to the parking lot to drive home. All he wanted was to get in his car, drive the 15 minutes to his house, and sleep. He didn't want conversation. He didn't want confrontation. He certainly didn't want to deal with a police officer. But that's exactly what was about to happen. "Excuse me," Officer Mercer called out, his tone immediately authoritative. "I need to talk to you." Judge Price stopped and turned, keys still in his hand. He saw the uniform, the patrol car, the young officer walking toward him with his hand near his belt. His first thought wasn't concern. It was exhaustion. Not now. Not today. Good evening, officer, Price said, his voice calm but tired. Is there a problem? Can I see some ID? Price frowned. ID? For what? I need to verify who you are. I'm a resident here. I'm walking to my car. What's the issue? Mercer's eyes moved to the Mercedes, then back to Price. That your car? Yes. Can you prove it? Price's jaw tightened. He'd been a civil rights attorney long enough to know where this was going. He'd been a judge long enough to recognize unlawful detention when he saw it. Officer, I don't need to prove anything. I'm on private property. I haven't committed any violation. You have no legal basis to demand my identification. Mercer stepped closer. I'm asking nicely. Show me your ID. And I'm declining. Politely. Because you have no reasonable suspicion and no probable cause. Are you refusing to cooperate with a police officer? I'm exercising my constitutional rights. Those aren't the same thing. And there it was. The moment that could have de-escalated. The moment where a more experienced officer would have recognized the situation for what it was. A tired man walking to his own car, and walked away. But Dylan Mercer didn't walk away. If this was you, do you think this officer even wanted a legal reason, or was he simply looking for justification after the fact? Drop a comment. Before we continue, where are you watching from? If this is your first time here, please hit that subscribe button. Stories like these need to be shared, and your support helps us bring more truth to light. Officer Mercer's hand moved to his radio. I'm going to call this in as a suspicious person refusing to identify. Judge Price remained calm, but his patience was wearing thin. Call whoever you want. But understand that when your supervisor arrives, I'm going to explain that you stopped me without cause, demanded ID without legal justification, and are now threatening escalation because I know my rights. Mercer's face flushed. You think you're smart? I think I'm informed. There's a difference. People like you. Price's eyes narrowed. People like me? Finish that sentence, officer. Mercer caught himself, realizing he'd almost said something he couldn't take back. People who don't cooperate make things harder for themselves. I'm not making anything harder. You are. You stopped me based on nothing. And now you're trying to justify it after the fact. Mercer's hand moved to his taser. Not drawing it. Just resting on the grip. A threat. A show of force. Last chance, Mercer said. Show me ID, or I'm detaining you. For what crime? Failure to identify. That's not a crime in Pennsylvania without reasonable suspicion. Which you don't have. I have suspicion. Based on what? Articulate it. What specific, observable facts led you to believe I've committed, am committing, or am about to commit a crime? Mercer stammered. Because there was no answer. There was no articulable suspicion. There was only bias. Only assumption. Only the belief that a black man didn't belong near an expensive car. I don't have to explain myself to you, Mercer said finally. Actually, under Terry versus Ohio, you do. If you're going to seize me, which is what detention is, you need reasonable, articulable suspicion. And you don't have it. Are you a lawyer or something? Or something? Judge Donovan Price had been in situations like this before. Not as the target, but as an observer. As an attorney. As someone who'd represented clients who'd been stopped, questioned, and detained for no reason other than the color of their skin. He knew how this worked. He knew the tactics. He knew the language officers used to justify unjustifiable stops. And he knew that fighting back, verbally, legally, asserting his rights, could make things worse. Could turn a bad stop into a violent encounter. But he also knew that compliance wouldn't protect him. That showing ID wouldn't end the humiliation. That submitting to unlawful authority just reinforced the idea that officers could do this without consequence. So he made a choice. He reached slowly into his jacket pocket. Mercer's hand tightened on his taser. What are you doing? Getting my identification. Since you've made it clear you're not leaving without it. Keep your hands where I can see them. They are where you can see them. I'm reaching into my jacket. Slowly. No sudden movements. Price pulled out a black leather wallet and opened it carefully. Inside was his driver's license, his credit cards, and something else. A metal badge. Gold. Heavy. Official. He removed it from the wallet and held it up so Mercer could see it clearly. Superior Court of Pennsylvania. Judge Donovan Price. Commonwealth of Pennsylvania. The badge caught the evening light, gleaming with authority that couldn't be questioned or dismissed. Mercer's eyes went wide. His hand fell away from his taser. His mouth opened, but no words came out. Price's voice was quiet, controlled, but absolutely devastating. I'm Judge Donovan Price, Superior Court of Pennsylvania. I've been working all night in my chambers at the courthouse. I'm walking to my car, which is registered in my name, parked in a lot where I'm a resident. And you stopped me because you assumed a black man couldn't afford this vehicle. Mercer's face went pale. Judge, I didn't. You didn't know? Because you didn't ask. You didn't verify. You didn't do anything except make an assumption based on race and class. You were just profiling. And you did it on camera. Mercer's eyes darted to his body camera, mounted on his chest, recording everything. The red light was on, had been on the entire time. Every word, every threat, every moment of this unlawful stop was documented. Judge, I'm sorry, I didn't mean. You meant exactly what you did. You saw a black man and decided he was suspicious. You demanded ID without cause. You threatened detention without justification. And you put your hand on your taser when I tried to assert my constitutional rights. Please, what's your badge number? Mercer fumbled with his uniform, reading the numbers aloud, his voice shaking. Price pulled out his phone and typed them into a note. And your supervisor's name? Sergeant Holloway. I'll be speaking with him. And with Internal Affairs. And with your department's legal counsel. Mercer looked like he was going to be sick. Judge, can we just forget this happened? Price's expression hardened. No, we can't. Because this happens every day to people who don't have my credentials, who don't have my authority, who don't have the legal knowledge to fight back. And they just have to accept it. Well, I'm not accepting it. And I'm making sure there are consequences. A second patrol car pulled into the lot. An older officer stepped out, Sergeant Holloway, responding to Mercer's earlier radio check. What's going on here? Holloway asked, immediately sensing the tension. Price held up his judicial badge. Your officer stopped me without cause, demanded ID without reasonable suspicion, and threatened detention when I asserted my rights. I'm Judge Donovan Price, Superior Court, and this entire encounter is on his body camera. Holloway's face went from confused to horrified in seconds. Judge Price. Yes. Holloway turned to Mercer, his voice low and furious. Get in your car. Now. Don't say another word. Go back to the station and wait for me. Mercer nodded and walked back to his patrol car, moving like someone in a daze. Holloway turned back to Price. Judge, I apologize. This should not have happened. No, it shouldn't have. But it did. And it's going to be addressed. I understand. We'll launch an investigation. I'm not relying on your internal investigation. I'm filing a formal complaint. And I'm considering legal action. Holloway nodded, knowing there was nothing he could say that would make this better. Price got into his car, started the engine, and drove away, leaving the sergeant standing in the parking lot. Realizing that his rookie officer had just destroyed his own career and exposed the department to catastrophic liability. What would you have done if a rookie officer talked to you like this? Even though you were the one with authority? Let me know. Before we continue, where are you watching from? If this is your first time here, please hit that subscribe button. Stories like these need to be shared, and your support helps us bring more truth to light. By noon, the complaint had been filed. Judge Donovan Price didn't wait. He didn't give the department time to spin the narrative or control the story. He went directly to Internal Affairs, submitted a formal written complaint, and requested a copy of Officer Mercer's body camera footage. Within hours, the Pennsylvania Judicial Defense Union was involved. Within a day, the state attorney general's office had been notified. Within a week, civil rights advocacy groups were calling for a full investigation and public accountability. This wasn't just a bad stop. This was a sitting Superior Court judge, an officer of the state judiciary, someone whose authority and credibility were beyond question, unlawfully detained by a rookie cop based purely on racial profiling. The optics were catastrophic. The legal exposure was enormous. The political pressure was immediate and intense. Internal Affairs launched its investigation immediately. The body camera footage was reviewed by multiple supervisors, legal advisors, and the department's civil rights compliance officer. What they saw was damning. Officer Mercer approaching without cause. Judge Price calmly explaining his rights. Mercer demanding ID. Price declining. Mercer escalating. Price revealing his judicial credentials. Mercer's immediate panic. The timeline was clear. The violation was obvious. The defense was non-existent. Investigators also pulled Mercer's personnel file and found the pattern that should have been addressed months earlier. 3 prior complaints, all involving unjustified stops, all involving people of color, all dismissed with minimal follow-up. Training evaluations noting poor judgment and overaggression. Recommendations for additional supervision that were ignored. A rookie officer with 7 months of experience and a documented pattern of racial profiling. Cleared for solo patrol because the department needed warm bodies on the street. The system had failed, and now it was paying the price. The city attorney's office received the complaint and immediately recognized the problem. This wasn't a case they could settle quietly. This wasn't a civilian they could intimidate into dropping the complaint. This was a judge, someone with institutional credibility, someone with legal expertise, someone who couldn't be dismissed or discredited. And the evidence was irrefutable. The city attorney called an emergency meeting with the police commissioner, the mayor's legal counsel, and the head of internal affairs. "We have a problem," the attorney said. "A big one. Judge Price has grounds for a federal civil rights lawsuit. And if this goes to trial, we lose. Badly." The commissioner tried to mount a defense. The officer was responding to what? There was no call, no complaint, no suspicious activity. He saw a black man near an expensive car and made an assumption. That's textbook racial profiling. Maybe we can argue he was being proactive. Proactive policing doesn't mean stopping people for existing. The Fourth Amendment still applies. And Judge Price knows that better than anyone in this room. Silence. "How bad is the exposure?" the mayor's counsel asked. "Worst case? 8 figures. Best case? High 7 figures plus mandated reforms and federal oversight." The room went quiet. Meanwhile, civil rights organizations were mobilizing. The NAACP Legal Defense Fund issued a statement calling for accountability and systemic reform. The American Civil Liberties Union requested all records related to Officer Mercer's training and prior complaints. Community leaders organized press conferences demanding answers. Legal experts appeared on local and national news, analyzing the case and predicting significant legal consequences. The Philadelphia Police Department tried to control the narrative, issuing statements about ongoing investigations, commitment to constitutional policing, and zero tolerance for misconduct. But the public wasn't buying it. Because the body camera footage, released through a public records request, told the truth. And the truth was undeniable. A rookie cop had racially profiled a superior court judge, demanded ID without cause, threatened detention without justification, and only backed down when he realized the man he was targeting had the authority to destroy his career. Officer Dylan Mercer was placed on unpaid administrative leave 3 weeks after the incident. He'd been interviewed by Internal Affairs, and his answers had only made things worse. "I thought he looked suspicious." Based on what? Just the way he was dressed. The car. It didn't match. "What do you mean it didn't match?" Silence. "Officer Mercer, are you saying you stopped Judge Price because you didn't think a black man in a hoodie should be driving a Mercedes?" "I didn't. I wasn't thinking about race." "Then what were you thinking about?" More silence. The deposition was a disaster. Mercer couldn't articulate reasonable suspicion. He couldn't explain his actions. He couldn't defend the stop. Because there was no defense. The Pennsylvania State Police Training Commission launched its own review, not just of Mercer, but of the entire Philadelphia Police Department's training and certification process. What they found was systemic failure. Shortened training periods due to staffing pressures. Inadequate psychological screening. Minimal bias training. Supervisors signing off on rookies despite documented concerns. The commission issued a formal report citing multiple violations of state training standards and recommending mandatory reforms. The department had no choice but to comply. Should police departments be allowed to hire rookies even before deep psychological bias screening is mandatory? Comment below. Before we continue, where are you watching from? If this is your first time here, please hit that subscribe button. Stories like these need to be shared, and your support helps us bring more truth to light. 6 months after the incident, Judge Donovan Price filed a federal civil rights lawsuit. The complaint named Officer Dylan Mercer, Sergeant Holloway, for inadequate supervision, and the city of Philadelphia as defendants. The claims were comprehensive and devastating. Fourth Amendment violation. Unlawful seizure without reasonable suspicion. 14th Amendment violation. Racial discrimination and denial of equal protection. Violation of Pennsylvania's Civil Rights Act. Municipal liability for inadequate training, supervision, and failure to address documented patterns of misconduct. Intentional infliction of emotional distress. The evidence was overwhelming. Body camera footage showing the entire encounter. Mercer's personnel file documenting prior complaints and training deficiencies. Internal affairs reports showing the department's failure to take corrective action. Expert testimony on racial profiling and Fourth Amendment standards. But the most powerful evidence was Judge Price himself, a sitting Superior Court judge. Unimpeachable credibility. Expert knowledge of constitutional law. A professional reputation built on fairness and integrity. No jury in the country would side with a rookie cop who'd racially profiled a judge in a parking lot. The depositions were brutal. Mercer's attorney tried to argue that his client had acted in good faith, that he'd made an honest mistake, that there was no intentional discrimination. But the body camera footage destroyed every defense. Officer Mercer, you said Judge Price looked suspicious. What specifically about his appearance or behavior suggested criminal activity? I don't know. It was just a feeling. A feeling, based on what observable facts? Silence. Was it the hoodie? Partly. Is wearing a hoodie suspicious? It can be. Is it illegal? No. Was it the fact that he was black? No. I wasn't thinking about race. Then why did you assume he didn't own the car he was walking toward? No answer. The deposition went on for hours. Every question exposed another layer of bias. Every answer revealed the lack of legal justification. Mercer's attorney knew they couldn't win. The city's attorneys knew they couldn't win. Everyone involved knew this case was indefensible. Settlement negotiations began. The city offered $3 million initially. Judge Price's attorneys rejected it immediately. This isn't about money, Price told his legal team. This is about accountability. This is about making sure this never happens again. This is about sending a message that you can't racially profile people and walk away with a slap on the wrist. The city came back with $5 million. Price rejected it again. $10 million, his attorney said during the next negotiation session. Plus mandatory reforms. Plus independent oversight. Plus public acknowledgement of wrongdoing. Non-negotiable. The city's attorneys balked. But they also knew that if this went to trial, a jury might award even more. And the reforms? Those were coming whether they agreed or not. The State Training Commission was already mandating changes. Federal oversight was looming. They could settle now and control the narrative, or they could fight and lose everything in court. They settled. $10 million. Paid to Judge Donovan Price. The settlement also included public acknowledgement that Officer Mercer's stop was unlawful and racially motivated mandatory bias training for all Philadelphia Police Department officers, extended psychological screening for all new hires, independent review of all stops and detentions for patterns of racial profiling, creation of a civilian oversight board with subpoena power requirement that all rookies complete at least 18 months of supervised field training before solo patrol, annual reporting on stop data, complaints, and disciplinary outcomes. The reforms were sweeping. The settlement was historic. And the message was clear. Racial profiling has consequences. Officer Dylan Mercer was terminated 8 months after the incident. The termination letter was final and unequivocal. Officer Mercer engaged in racial profiling, unlawful detention, and conduct that violated department policy, state law, and federal constitutional protections. His actions have exposed the city to significant legal and financial liability and have damaged public trust in law enforcement. His employment is terminated immediately, and his law enforcement certification is revoked. Mercer appealed through the police union. The appeal was denied. His name was entered into the National Decertification Index, ensuring he would never work in law enforcement again, not in Pennsylvania, not anywhere in the United States. At 24 years old, his career was over. His future in policing, destroyed by a single decision made in a parking lot on a quiet March evening. Judge Donovan Price returned to the bench. When he entered the courtroom for the first time after the settlement, attorneys on both sides stood and applauded. Court staff joined in. Even the bailiffs clapped. It was unprecedented. Judges don't receive standing ovations. But this wasn't just about a case. It was about dignity. about standing up to injustice, about using power and privilege to protect people who don't have either. Price raised his hand for silence and spoke briefly. Thank you. But I didn't do this for applause. I did it because it needed to be done. Because what happened to me happens every day to people who don't have my credentials, my authority, or my resources. And they just have to accept it and move on. That's not justice. That's not equality. And until we fix the systems that allow this to happen, we haven't done our job. The room was silent. Then he sat down, picked up his gavel, and got back to work. Do you think civil lawsuit money actually changes future police behavior? Or do you think departments will keep ignoring bias until consequences get even bigger? Let me know. Before we continue, where are you watching from? If this is your first time here, please hit that subscribe button. Stories like these need to be shared, and your support helps us bring more truth to light. Let's be clear about what happened here. No crime occurred. No threat existed. No emergency justified intervention. A black man walked to his car. That's it. That's the entire factual basis for Officer Dylan Mercer's stop. Everything else, the demand for ID, the threats of detention, the hand on the taser, was built on assumption, on bias, on the belief that a black man in a hoodie couldn't possibly belong near an expensive vehicle. This wasn't about public safety. This wasn't about crime prevention. This was about perception, about who gets to occupy certain spaces, about whose presence is automatically questioned, and whose is accepted without scrutiny. Judge Donovan Price changed more than just his own case outcome. The $10 million settlement sent a message. Racial profiling is expensive.
We're out here enjoying the afternoon, having a couple sneaker bars. That's it. Sun's out, my kid's happy, and then...
Sir, can I ask what you're doing in this area? Do you live around here?
You hear that? We're standing in a park, minding our business, and he wants to know if we...
Belong.
Because I'm black and my son isn't.
Officer Brent Malik had 5 years on the Chicago Police Department, but only 3 of those years actually at street patrol rank. He was known for proactive suspicion stops, especially in neighborhoods he thought people didn't fit into. One sunny afternoon in Chicago, everything changed permanently. A black father in his 30s, Special Agent Darius Coleman, was casually walking down a quiet residential sidewalk with his little son, Eli, who was holding a chocolate sneaker bar. They were laughing, enjoying the weather, enjoying the break. No crime. No argument, no disturbance, nothing, just a father and son moment. But Officer Malik saw them and instantly viewed the scene through bias. He believed Darius couldn't be the father of that little white boy. That false assumption triggered an escalation that would end in a wrongful arrest, national outrage, and a $5 million legal consequence. Before we continue, where are you watching from? If this is your first time here, please hit that subscribe button. Stories like these need to be shared, and your support helps us bring more truth to light. Lincoln Square, Chicago. A quiet residential neighborhood on the north side where the streets are wide, the trees are old, and the sidewalks are busy with people walking dogs, pushing strollers, living ordinary lives. It was 2:30 on a Thursday afternoon. The sun was out. The temperature was perfect. The kind of day that makes you forget about work and deadlines and everything else. Special Agent Darius Coleman had been with the FBI for 13 years. 13 years working violent crime task forces, organized criminal enterprises, and cross-jurisdictional investigations. He'd testified before grand juries. He'd coordinated with ATF and DEA. He'd been recognized for his work on human trafficking cases. His supervisors called him steady. His colleagues called him reliable. But that afternoon, he wasn't Special Agent Coleman. He was just Dad. Walking down the sidewalk with his 7-year-old son, Eli, talking about nothing in particular, video games, what they'd have for dinner, whether they should stop at the park on the way home. Eli was small for his age, with light brown hair, freckles across his nose, and a gap-toothed smile. He held a half-eaten chocolate sneaker bar in one hand and his father's hand in the other. They were laughing. They were safe. They were happy. And to anyone watching, they looked exactly like what they were. A father and son enjoying an afternoon together. But not to everyone. Darius had adopted Eli 3 years earlier, after fostering him for 18 months. Eli's biological parents had lost custody when he was 4. Neglect, substance abuse, instability. The foster system had placed him with Darius, who was single, financially stable, and cleared for placement after a rigorous vetting process. At first, Eli had been quiet, withdrawn, uncertain. But over time, trust built. Routines formed. Love took root. By the time the adoption was finalized, Eli called Darius Dad without hesitation. He slept easier. He smiled more. He belonged. The fact that Darius was black and Eli was white didn't matter to them. It was just a detail, a fact with no weight inside their home. But outside, that was different. Darius had learned quickly that some people couldn't accept what they saw. Strangers in grocery stores would ask if he was babysitting. Teachers at Eli's school initially assumed he was a family friend, not the parent. Airport security had once questioned whether Eli was traveling willingly. Darius handled it with patience, documentation, and the kind of exhausted grace that comes from knowing the world won't always see you the way you are. But he'd never expected a police officer to see him as a threat. Officer Brent Malik had been with the Chicago Police Department for 5 years, but his record told a more complicated story. He'd spent his first 2 years on administrative duty, dispatching, desk work, evidence processing. When he finally moved to street patrol, his supervisors noted enthusiasm, but also tendency to overinterpret situations. In 3 years on patrol, Malik had generated 6 complaints. All of them involved stops in neighborhoods where the person detained didn't seem to belong. His words, documented in incident reports. A black teenager walking through a predominantly white area. A Latino family having a picnic in a park Malik considered out of their zone. An Asian man parked outside a business Malik thought looked too expensive for him. None of the complaints had led to discipline. They'd been closed with retraining recommendations and diversity workshop requirements that Malik attended but never internalized. So he stayed on patrol, and the pattern continued. That afternoon, Malik was driving through Lincoln Square, scanning the streets, looking for anything that didn't fit his mental map of how the neighborhood should look. And then he saw them. A black man, walking with a white child, holding hands, laughing. Malik's mind didn't register father and son. It registered mismatch. Something wrong. Something suspicious. In his view, a black man in this neighborhood with a white child could only mean one thing. Something illegal was happening. He didn't consider adoption. He didn't consider blended families. He didn't consider that his assumption was rooted in bias, not evidence. He just acted. Malik slowed his patrol car, made a U-turn, and circled back. Do you think cops judge situations based on stereotypes more than facts? Drop your answer below. Darius noticed the patrol car before it stopped. He'd been a federal agent long enough to recognize when someone was watching him. The slow pass. The brake lights. The turn. He squeezed Eli's hand gently. Hey, buddy. Just keep walking normally, okay? Eli looked up, confused. Why? Because a police officer might want to talk to us. It's fine. Just stay close. The patrol car pulled up alongside them and stopped. The window rolled down. Excuse me. Officer Malik called out. Can I talk to you for a second? Darius stopped and turned, keeping Eli slightly behind him. Good afternoon, officer. Is there a problem? Malik stepped out of the car, his hand resting near his belt. I need to see some ID. Darius frowned. Can I ask why? Just routine. ID, please. Routine for what? We're just walking. Malik's eyes moved to Eli, then back to Darius. Is that your son? And there it was. The question that shouldn't have been a question. Darius's jaw tightened, but he kept his voice calm. Yes, he's my son. Your biological son? That's none of your business. It is if I'm investigating a situation. Darius's eyes narrowed. Investigating what? What situation? We're walking down the street. There's no crime. No complaint. No reason for you to stop us. Malik stepped closer. I need to verify the relationship between you and this child. Eli looked up at Darius, his eyes wide, scared. Dad. Darius crouched down to Eli's level, his voice gentle. It's okay, buddy. This officer just has some questions. Stay right here with me. He stood back up and faced Malik, his voice firmer now. Officer, my name is Darius Coleman. I'm a special agent with the FBI. This is my son, Eli. He's adopted. We live 6 blocks from here. I can show you my credentials and documentation, but I need you to understand that you're stopping us without cause. Malik's expression didn't soften. If anything, it hardened. FBI, huh? Sure. Let me see your ID. This is where bias becomes dangerous. Officer Malik didn't believe Darius. Not because Darius was lying. Not because the story was implausible. But because Malik had already decided what he was looking at. A black man. A white child. And in Malik's mind, Those two things didn't belong together unless something criminal was happening. Adoption didn't register. Multiracial families didn't register. The possibility that he was wrong didn't register. All Malik saw was a threat to be neutralized. Darius reached slowly into his jacket pocket. I'm getting my credentials now. They're in my inside pocket. Keep your hands where I can see them. They are where you can see them. I'm a federal agent. I know the protocol. Darius pulled out his FBI credentials and held them out. Malik barely glanced at them. Those could be fake. Darius stared at him, disbelief creeping into his expression. Officer, these are legitimate federal credentials. You can verify them with one call. My badge number is right there. I'll decide what gets verified. Right now, I'm concerned about the welfare of this child. Eli's voice was small, frightened. Dad, I want to go home. Darius put a reassuring hand on Eli's shoulder. We will, buddy. Soon. He turned back to Malik, his voice dropping into something colder, more controlled. Officer Malik, he read the nameplate. You need to call your supervisor. Right now? Because what you're doing is profiling. You're stopping a federal agent and his son based on nothing but bias. And if you continue, this will end very badly for you. Malik's face flushed. Are you threatening me? I'm warning you. There's a difference. Turn around and put your hands behind your back. Darius's eyes widened. You're arresting me? I'm detaining you until I can verify this child's safety. His safety? He's with his father. He's perfectly safe. This is insane. Malik reached for his handcuffs. Turn around. Now, should officers be allowed to demand proof of parenthood on the street without cause? Let me know what you think. Darius looked down at Eli, who was starting to cry, his small hand gripping his father's jacket. This was the moment. The choice that every black parent dreads. Comply and submit to something unjust. Show your son that authority can violate you and there's nothing you can do. Or resist and risk escalation, risk violence, risk trauma, risk making things worse. Darius chose survival. Eli, he said softly, kneeling down again. I need you to be brave for me, okay? I'm going to talk to this officer, and then we're going to go home. But I need you to stay calm. Eli nodded, tears streaming down his cheeks. Why is he doing this? I don't know, buddy. But it's going to be okay. Darius stood and turned to Malik, his voice steady but laced with controlled fury. I am complying under protest. I'm a federal agent. This is an unlawful detention. And my son is watching you traumatize him for no reason. Malik pulled Darius's arms behind his back and snapped the handcuffs on. You can file a complaint later. I'll be filing a lawsuit. The scene was surreal. A black FBI agent, handcuffed on a public sidewalk, while his 7-year-old adopted son stood nearby, sobbing, not understanding why his father was being treated like a criminal. Passers-by stopped and stared. A few pulled out phones and started recording. An older woman approached cautiously. Is everything all right? She asked. That's Darius. He lives in the neighborhood. That's his son. Malik ignored her. Ma'am, step back. But I know him. He's not. Step back. The woman retreated, shaking her head, her phone already out, dialing. Darius stayed calm, his voice measured despite the rage simmering beneath. Officer Malik, you are making the worst mistake of your career. I've identified myself. I've shown you my credentials. I've told you this is my son. And you're arresting me anyway. Do you understand what happens next? Malik didn't respond. He just radioed dispatch. Dispatch, this is Unit 19. I have a possible child welfare situation. Need child protective services and a supervisor to my location. Lincoln Square, corner of Lawrence and Levitt. Darius closed his eyes, breathing slowly, trying to stay composed. For Eli. For himself. For the case he knew was about to unfold. Dad, Eli's voice was shaking. Are you going to jail? No, buddy. This is a mistake. A big mistake. But I'm not going anywhere without you. Within minutes, a second patrol car arrived. Then a third. Officer Sandra Lynn stepped out, a 12-year veteran who'd worked with Malik before and had learned not to trust his judgment. What's going on? She asked. Malik gestured toward Darius. Possible abduction case. Black male with a white child. Claims to be the father, but it doesn't match. Lynn's eyes narrowed. Doesn't match. Just look at them. Lynn walked over to Darius, who was still handcuffed, standing protectively near Eli. She looked at the credentials lying on the ground where they'd been dropped. She picked them up and examined them carefully. Malik, she said quietly, these are real. This is a federal agent. Could be fake. They're not fake. I've seen FBI credentials before. These are legitimate. She turned to Darius. Agent Coleman, I'm Officer Lynn. I'm going to get you out of those cuffs. I apologize for this. Darius nodded, his voice tight. Appreciate it. But the damage is done. My son just watched me get arrested for walking down the street with him. Lynn unlocked the handcuffs and handed Darius his credentials. I understand. And I'm sorry. Malik stood off to the side, still convinced he was right, still unable to see what everyone else could. That he'd profiled a federal agent and traumatized a child based on nothing but racist assumptions. Why do some officers interpret calmness and cooperation as suspicious defiance? Comment your thoughts. The situation escalated quickly once dispatch connected the dots. A call had come in from a witness, one of the neighbors who'd recognized Darius, alerting the FBI field office that one of their agents had been detained by Chicago PD. Within 20 minutes, 2 FBI vehicles arrived on scene. Special Agent Maria Reyes and Special Agent Tim Hodges stepped out, both in suits, both visibly angry. Reyes recognized Darius immediately. Coleman? What the hell happened? Darius gestured toward Malik. That officer arrested me for walking with my son. Said he didn't believe Eli was mine. Reyes turned to Malik, her voice cold. You arrested a federal agent? Malik stammered. I was investigating a potential child welfare issue. Based on what? What evidence did you have? He's black, the kid's white, and what? Adoption doesn't exist? Multiracial families don't exist? You just assumed criminality because of skin color. Malik didn't have an answer. Hodges stepped forward, his voice low and dangerous. Did you verify his credentials before you cuffed him? I was going to. That's a no. You arrested a federal agent without verifying his identity. Do you understand the legal nightmare you just created? A supervisor arrived moments later, Sergeant Raymond Torres, a 20-year veteran who'd seen enough to know when someone had crossed a line that couldn't be uncrossed. Officer Lynn briefed him quickly. Torres listened, his expression growing darker with each detail. Then he turned to Malik. Give me your badge and weapon. You're on administrative leave effective immediately. Malik's face went pale. Sarge, I was just. You arrested a federal agent and traumatized a child based on racial profiling. There's no just about it. Badge. Gun. Now. Malik handed them over, his hands shaking. Torres turned to Darius. Agent Coleman, on behalf of the Chicago Police Department, I apologize. This should never have happened. We'll be conducting a full investigation, and I'll personally ensure you have access to all body camera footage and reports. Darius nodded but didn't speak. His focus was on Eli, who was still crying, still scared, still trying to understand why the world had just turned hostile. Darius knelt down and pulled his son into a hug. It's over, buddy. We're going home now. Eli buried his face in his father's shoulder. I don't like police officers. Darius's heart broke. The crowd that had gathered was silent, watching as the scene played out. Phones were still recording. The evidence was everywhere. Sergeant Torres pulled Officer Lynn aside. Get the body cam footage to IA immediately, and make sure Agent Coleman gets copies. Lynn nodded. Already on it. Torres looked at Malik, who was standing alone now, realizing the full weight of what he'd done. You're done, Torres said quietly. You know that, right? Malik didn't respond. He just stared at the ground. Because he did know. This wasn't something he could explain away. This wasn't something the union could protect him from. He'd arrested a federal agent. On camera. In front of witnesses. Based purely on racial bias. His career was over. Should police officers be on desk duty automatically after one race-based complaint? Drop your answer. Be why that evening, the story had gone viral. Video from multiple witnesses showed the entire encounter. Darius being handcuffed, Eli crying, Officer Malik's justification that he didn't believe a black man could be the father of a white child. The outrage was immediate and intense. Chicago cop arrests FBI agent for walking with adopted white son. Racial profiling. Federal agent detained while parenting his own child. $5 million lawsuit filed after officer arrests black father in front of his son. The story had everything. Racial bias, a federal agent, a traumatized child, clear video evidence. It dominated news cycles for weeks. Civil rights attorneys contacted Darius within hours. This wasn't just about an unlawful arrest. This was about the fundamental assumption that black people couldn't be trusted as parents to white children. It was about bias so deep it overrode common sense, protocol, and basic human decency. The lawsuit named Officer Brent Malik, his supervisors, and the Chicago Police Department. The claims were devastating. Unlawful arrest without probable cause, racial profiling and discrimination, violation of federal civil rights, intentional infliction of emotional distress on a minor, failure to train and supervise officers on bias, and multiracial families. The city's attorneys reviewed the case and came to a grim conclusion. This was indefensible. Body camera footage showed everything. Malik's stated reason for the stop: his refusal to believe Darius's credentials. His arrest based solely on the racial mismatch he perceived. The city settled within 6 months. Over $5 million. Paid to Darius Coleman and held in trust for Eli's future. Officer Brent Malik was terminated 8 weeks after the incident. The termination letter was final and unambiguous. Officer Malik engaged in racial profiling, unlawful arrest, and conduct unbecoming an officer. He detained a federal agent and traumatized a child based on racial bias. His actions violated department policy, state law, and federal civil rights protections. His employment is terminated immediately. Malik's name was entered into the National Decertification Index. He would never work in law enforcement again. He attempted to appeal, but the union declined to support him once the FBI submitted its formal complaint and the video evidence became public. Malik issued a brief statement through an attorney. I made a serious error in judgment. I allowed my perceptions to override protocol, and I caused harm to Agent Coleman and his son. I take responsibility for my actions. It was too little, too late. The Chicago Police Department faced intense scrutiny. How had Malik, with 6 prior complaints involving racial profiling, remained on patrol? Why had his supervisors ignored the patterns? What training existed to prevent officers from profiling multiracial families? Internal Affairs launched a comprehensive review. What they found was systemic. Complaints filed but not taken seriously, training requirements ignored, supervisors pressured to close cases quickly to meet administrative quotas. The Department of Justice opened a pattern and practice investigation. Reforms were announced: mandatory bias training before patrol, real-time body camera review for all detentions involving children, a dedicated unit to investigate discrimination complaints, extended probationary periods for new officers. Special Agent Darius Coleman became a reluctant advocate. He testified before city council. He spoke at community forums. He gave interviews to national media. His message was consistent. This wasn't about me. I had the credentials, the resources, the standing to fight back. But what about the parents who don't? What about the black fathers who get stopped, questioned, and separated from their children, but don't have a badge to prove their worth? What about the families torn apart because an officer couldn't imagine that love doesn't see color? He paused during one interview, his voice breaking slightly. My son asked me why the police officer didn't believe I was his dad. How do I answer that? How do I explain that some people look at us and only see what they've been taught to fear? The interviewer had no answer. Eli received counseling. Slowly, over months, the trauma began to fade. But the memory remained. He was more cautious around police now, more aware that the world saw him and his father differently than they saw themselves. Darius hated that his son had learned that lesson so young. But he also knew it was a lesson that might one day keep him safe. Should racial bias cases bypass internal review and automatically go to federal level? Let me know in the comments. This wasn't just a bad stop. This was a window into how bias operates when it's backed by authority. Officer Brent Malik didn't see a father and son. He saw a racial mismatch. And in his mind, that mismatch could only mean one thing. Something criminal was happening. He couldn't imagine adoption. He couldn't imagine multiracial families. He couldn't imagine that love transcends skin color. His bias was so deeply embedded that he ignored evidence, dismissed credentials, and arrested a federal agent, all because his worldview couldn't accommodate what was right in front of him. Systemic racism isn't always violent. Sometimes it's quiet, insidious, built on disbelief rather than aggression. It's the assumption that a black man can't be trusted with a white child. It's the refusal to see family where family exists. It's the weaponization of concern to justify profiling. And when that bias is empowered by a badge, a gun, and the authority of the state, It doesn't just harm individuals. It tears at the fabric of trust that holds communities together. Brent Malik's career is over. That's justice. The city paid over $5 million. That's accountability. But money and terminations don't undo trauma. They don't erase the memory of a 7-year-old boy watching his father get arrested for being black. The real question is, what changes now? Do departments finally take bias complaints seriously before they escalate? Do they finally train officers to recognize that families come in all configurations? Do they finally accept that profiling isn't proactive policing? It's discrimination with a badge? Because if we don't fix the system that put Brent Malik on the street, if we don't address the bias that taught him to see threats instead of families, then we're just waiting for the next officer, the next victim, the next child who learns too young that the world